Yeah, tell me what happened. It's a POM now.
Yes.
Isn't this her first one, or?
Yes.
Okay.
Yes, this is her first one, and she was on the prior record at all. She's a student here, and she was driving down Guadalupe when she was pulled over and arrested and found 19 grams of LSD. The officer said that he saw
19 grams.
19 grams of LSD, and the officer said that it was her, so that she was driving on the road and smoking a joint at the same time. Anyway, she was arrested, and like I said, she has a prior criminal history, and I was just hoping to do something anyway, maybe getting this knockdown with the ICs and charge maybe.
I don't know about 19 grams. That sounds a little bit outrageous to me. Now, what was she doing with this 19 grams?
Well, the 19, she had just, I have no idea what anybody did with 19 grams. And this is the first time she's been in this type of trouble. We've already know she's in it. She's going to be in class, taking class. She obviously is concerned that something like this could hurt her down the road with regard to, educational opportunities, job prospects, things of that nature.
Well, those are all types of things that she probably should have thought about before she. 19 years, 19 grams. That doesn't sound too good to me.
Yeah, 19 grams. I mean, that's not good. But I was hoping to do something to just ease this up a little bit on her.
What are you looking to do?
There was no
Counselor?
evidence. I'm sorry.
What are you looking for exactly? I'm just going to be honest with you. I think 19 grams and Class C, that just doesn't rhyme when it comes out of my mouth. To be honest with you.
Well, I mean, there's no nothing in the report to indicate that she was driving erratic. Now, she was respectful of the
Okay.
officer.
Okay.
I said this is
Okay.
the first offense, and
Okay.
just obviously it ruin her life. I mean, 19 grams, notwithstanding. I would just really like to come to some sort of.
Well, I'll be honest with you. I understand she's so she. You say her driving was okay, and I think that's something that definitely goes in your favor. But I'll tell you what, I think the 19 grams in Class C are about as far away as New York and LA right now. You have something in between. Maybe you can. What exactly do you have in mind?
Well, the way I'm thinking, I mean, you're busy, you've got tons of these cases today, and I've got other clients. It's what I was just trying to see if we reach some sort of agreement that would keep us from having to go forward with this here, okay? Which we are prepared to do. But given, like I said, the lack of criminal history and everything else that she's got in her favor, I mean, even if we go and negotiate in court, I mean, the worst thing she's going to do is she'll wind up with deferred adjudication on the Class B. So it was like, that's why I put her out. I mean, I'm not trying to get her off scot-free.
So is she's interested in doing probation?
Probation, I don't know. I don't think, given these facts, and that, like I said, if she went unnegotiated before the court, she probably wouldn't get probation. She probably might have deferred adjudication on these facts and without having a prior record. That's why I'm saying the next logical thing would be to look at reducing to a Class C, either a guilty plea on a paraphernalia charge or for disposition on a paraphernalia charge.
Mr. Hamilton, the judge is going to need somebody at the bench to go over the docket in just a minute.
Okay. Well, sir, I understand what you're saying here, but as I see it, you've come in here to visit me and don't have a whole lot to offer me. I'm willing to talk about a deferred adjudication, but a Class C misdemeanor is just not in consideration with 19 grams of marijuana.
Yeah, and I mean, we can go on and go over the hearing, and we do have several issues that we're going to.
Okay, well, what's your issue?
Well, I don't feel, I mean, this is not anything personal, but I've been in this exact spot before, and one time I was coaxed into discussing my issues a little bit, and we didn't reach an agreement, and I'm not about to get. So I'm just, it's a stop, and there are things that we're going to talk about, genuine issues, I think, that need to be addressed. That's, we'll go to the hearing, but I mean, to forego the hearing, I just not in good conscience. I mean, there's going to have to be some.
Judge needs some somebody at the bench.
There's gonna have to be a reason for
Going over the docket.
We'll go here and wind up the same with, the spot she would be, without getting anything beyond.
Okay, well, I'm not gonna be able to offer you a Class C. If you wanna talk to her and see, what type of probation or whatever she's willing to do, but I think 19 grams, I'm not willing to just let her off scot-free. I think somebody needs to look after her a little bit. So if you wanna talk to her and see what exactly she's willing to do, and when she's willing to come back to some sort of serious offer, then maybe we can look at this a little more closely.
All right, well, we just want to be there. But I appreciate your time.
Okay, well, thank you.
Thank you.
Pleasure to meet you.
Pleasure to meet you.
Sorry about that, Tony, I just.
How are you doing?
Good, how you doing?
This is Walker Herrera.
Bill Swain, nice to meet you.
You already meet the client. Yeah, me. A lot of fun.
Well, I hope it wasn't too bad.
All
So what you got today?
right. I'm representing Angela Austin in a case of you going up very soon. Do you know anything about the facts?
And what did she do?
She was caught on Guadalupe on January 6th with possession of marijuana.
What's the setting today?
The setting, we're going to be going on in about 20 minutes.
Well, what is the setting? What setting is it set on?
I believe we're going to be going in front of the judge. So.
Is it a pretrial hearing?
Yes, we're trying.
Okay. Okay, so what are the facts here? What are you looking to do?
In regards to her case, she was driving on Guadalupe. Supposedly saw her with a white object which appeared to be like a cigarette or a possible marijuana joint. He pulled her over and found that it was marijuana. Luckily found other marijuana as well as a bag of marijuana.
So he saw her smoking marijuana,
Well, he saw her smoking something.
and it turned out to be marijuana.
Luckily he did. I mean, those are just undisputed facts. We're not hiding anything.
Okay, so what exactly are you looking to do? What are you asking me for?
You know what? This case is rather important to me. I have many other cases, murders and rapes, and being about answer, the clients, he has a question or what's going on, but this one is actually rather special to me. I met her and really got to know her really well. And she's just a 19, 20-year-old kid who's in college at UT, actually still enrolled, very good grades. She's worried about her future. As you know, we all were back in those days. She realizes it's a mistake, and I've been talking with her a lot about this issue, kind of like a little mentor mentee scenario. And I
Well, be careful when you ride in her car.
That's a problem we've addressed, and we've personally taken care of this issue. As you can see
Issue
here.
has been taken, so she's not using drugs anymore?
No, we've actually put her in a drug rehab program, so we can take care of that issue personally. She voluntarily did this issue.
Okay, this looks good. This is something to put in the files. She's completed this already.
Yes, she has.
Well, that doesn't look too bad. Well, what exactly, let's get down to business. We don't have a lot of time. What exactly do you want to do? What are you looking for?
Well, first and foremost, I want to protect her future, and by that, is I want to make sure she doesn't have a criminal record. And so I would like the state to give her a Class C.
Well, I'll tell you what, with this documentation and everything, and your little friendly relationship with her, I may be willing to give her a Class C if she can take a drug test today and be clean.
You like her to take a drug test?
Today, yes. Can she do that?
I'd like to talk with her first.
So do you think she can do it or she can't?
I'd like to talk with her.
Okay. That offer's on the table today only, and if only if it's contingent upon her passing the drug test. I'm willing to let her go if she's cleaned herself up already, but if you need to talk to her, you can.
That's it, sir.
Okay.
Come talk to me, I'm Angela. All right, you got dismissed, right? Thank you. Okay. Okay. How long does this take your system?
was at a party Saturday night, some fellas are smoking a joint, you know, across the room from me, I might have some secondhand smoke in me or something.
Ignore it.
Took a couple of hits off of the joint Saturday night.
Even though you
I mean, it was just a cut, you know. Yeah. Save me, please.
Okay, so for my client, and we have some issues regarding the test, and we
She's not clean.
No, I didn't say that at all. We just have some concerns with regarding the test. There may be some possibility that, who would be administering the test first?
We'll do that in the standard manner. You're pretty familiar with that.
Yes,
The issue is, can she, will the test be clean?
She can take the test, whether it will or not be clean. There's various issues that could screw the exam up, and so I think in her best interest, I would advise her not to. You know, you can take an alcohol breathalyzer test, and somebody can screw it up, and that's what we're worried about.
Well, we've got those things worked out pretty well. I'll tell you the biggest thing that could be screwed up right now. You were caught in your car smoking a joint with 19 and a half grams of marijuana.
That was less than 2 ounces. And the thing is, regarding the driving, if you look at the police report, she was not speeding, there was no sign of speeding, she was below the speed limit. There was no signs of erratic behavior, no swerving, she was driving within the manner of the law. And she did stop at a stop sign. There was no signs of impropriety in the driving help.
Okay. Well, I'll tell you what, I'm not willing to give you a Class C without the drug test. And if for whatever reason she's not willing to do that, there's no way I'm going to give you a Class C. But I will do this: we can put her on deferred adjudication, and she'll have to take some drug tests as a condition of this agreement. So what do you say to maybe a year of deferred adjudication?
So I have a deferred adjudication on the Class B.
On the Class B?
DOI. However, she will have a criminal record. Is that my correct position?
Well, she'll have an arrest record.
And is there any possibility of any expulsion?
Counselor, you're going to have to go back and look in the books for that. I'm your negotiator. I'm not your law professor. But well, the offer I'm going to write in the file here is 1 year deferred adjudication with monthly drug tests as a condition.
Well, before we put the pen on the paper, I just want to know in wiggle room before we go to trial. We have a pre-trial hearing right here. We're all ready to go. And I'm just here for one reason only, is to protect this innocent girl. She did something wrong. She wholly admits it. And as you've seen, she's ready to go forward in life. She's taking these classes. And also, she's ready to go with community service. You just give her the amount of hours. She has locations. And if you don't like those locations, we'll be willing to go to any location that you would like.
Okay, well, I'll tell you what, if she's willing to do some community service, we can work something out. How about I cut that in half? We'll go 6 months deferred adjudication and with 80 hours of community service.
How about 160 community service and not the final condition of Class C?
No deal there, Counselor. If she wants to do, I'll tell you what, she can get off with not a whole lot of community service if she can just do the service of peeing in a cup for us. But if she's not willing to do that today, she's not going to get a Class C. If she wants to do 100 hours of community service, 6 months of deferred adjudication with a monthly visit to the urine inspector, then we can work something out on that. But otherwise, no go. No. If she's not, I want that's 19 grams.
Just need somebody at the bench pronto.
Well,
Go to
I'll
the
tell you
doctor.
what, that 19 grams, that's a pretty good amount of marijuana, and I want to make sure that she's clean. And if I can't do that today, and I have a suspicion that she's not clean, then I tell you what, we're going to have to look after her for a little while. And I'm willing to offer you 6 months deferred adjudication, 100 community service hours, and monthly tests.
And we'll see. She's ready and she's willing to do all the community service it takes. And then also, we're unable to tell you, but her parents are taking away the car privileges.
Okay.
And we've informed her father as well regarding this. We all want to work this out for her best interest in the future. And we don't want to do something to harm her future.
Well, I understand. I was gonna suspend her driver's license anyway.
Well, her parents will definitely wouldn't get that badge. They took care of that.
Okay, okay.
So we were willing to do the monthly checkups, as much community service as you want. I mean, she'll build you a new
Okay,
center.
okay. Well,
But we can just postpone the testing until at the end of the month.
oh, we can do that. We can do that. The offer's on the table, 6 months, deferred adjudication, 100 community service hours, with a $400 fine, and monthly testing as a condition of her deferred adjudication.
And can we do the testing after this?
The testing will, you can wait to plead out the case whenever you want to. And that will begin, her deferred adjudication will begin until the case,
Well, I just want to make sure the drug testing you're requiring about, we can do it a month from now.
you seem pretty concerned about when we do that first drug test, so.
Judge,
Well, it could be a
judge is
problem.
demanding Mr. Swaim's appearance at the bench.
Son, I don't know, I gotta get moving, but I don't know, do we have a deal or not here?
Well, you have deferred adjudication on the table?
Deferred adjudication, 6 months, $400 fine. We've got 100 community service hours and monthly testing. We have a deal. The judge is calling us.
How about we go take care of the pre-trial hearing?
Okay, okay. We'll see you in there. 2397 to order, State of Texas versus Angela Austin. The case is called for a pretrial and a motion to suppress. Is the state ready?
Yes, we are, Your Honor.
Is the defense ready?
Yes, Your Honor, defense is ready.
Okay, call your first witness.
Your Honor, on the motion to suppress, the defense would like to call Officer Mike Sheffield to stand, please.
Mr. Sheffield, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
So help you God.
Please state your name for the record.
Yes, sir. My name is Michael Sheffield.
All right, Officer Sheffield, how are you doing today?
Fine, sir.
All right, I'm just going to be questions for you. Try not to take up any more of your time, if need be. You're currently employed by Austin Police Department
Yes, sir.
as a patrol officer,
That's correct, sir.
and you were working for APD as a patrol officer on the afternoon of January 6, 2004,
Yes, sir.
and it was on January 6th of 2004 which you arrested Mrs. Austin
I did, yes.
for possession of marijuana.
That's correct.
Now, on that day, you were on patrol around the area of 1500 block, Guadalupe, is that correct?
Yes, sir.
Is that a routine patrol?
It was.
And you were in a march unit?
Yes, sir.
And this is where you first noticed the vehicle driven by Ms. Austin.
Yes, sir.
It was a black Camaro
That's correct.
with tinted windows.
Yes, sir.
Your unit and Mrs. Austin's car were both headed southbound Guadalupe at the time.
Yes, sir.
And this is where you first observed Ms. Austin smoking what you believe to be marijuana.
That's correct, sir.
And you observed this while driving next to Ms. Austin's vehicle.
That's correct.
And she was to your immediate right.
Yes, sir.
And your unit was, if I have it correctly, in the far left lane.
That's correct.
So that means she was in the middle lane.
One of the middle lanes, yes, sir. There's 2 middle lanes in that block.
Okay. A few moments later, your unit and Ms. Austin's vehicle stopped at a light,
Yes, sir.
and that's the light at 15th and Guadalupe?
That's correct, sir.
Okay. And the positions of the automobiles were still the same. Ms. Austin was still in the middle lane.
She was still in the middle lane, yes,
Sorry,
sir.
let me rephrase that. Ms. Austin's, at the light, Ms. Austin's car was still in the lane to your right.
That's correct.
Okay. Now, at the light at 15th Guadalupe, there was a car ahead of your unit at the light.
That's correct.
And Ms. Austin's vehicle was actually in the front at the light. I mean, in the first, number one position, waiting on the light.
That's correct, sir.
Okay, so at this point, you were viewing Ms. Austin's vehicle at an angle.
That's correct.
Okay. So your vantage point was one car back from Ms. Austin's vehicle, basically,
Yes, sir.
and to her left.
That's correct.
And when the light turned green, then your unit and Ms. Austin's vehicle both proceeded south down Guadalupe.
Yes, sir.
And you pulled Ms. Austin over then around the 1300 block of Guadalupe?
Yes, sir.
Okay. And you found marijuana in the car?
Yes, sir, I did.
A butt in the ashtray?
Yes, sir.
And I believe a baggie under Ms. Austin's seat?
Yes, sir.
In your incident report, you stated your observation of Ms. Austin led you to believe that she was engaging in criminal activity. Is that correct?
Yes, sir.
Based on your observations, you concluded that Ms. Austin was smoking marijuana.
Yes, sir.
And you based this conclusion on a number of factors, isn't that correct?
Yes, sir.
That Ms. Austin was smoking something that appeared to be self-rolled,
That was one of the factors, yes, sir.
okay, and that what she was smoking appeared to be about 1 inch in length,
That's correct.
and that what she was smoking, she was holding it between her thumb and her index finger.
Yes, sir.
Also, and also because, as you stated in your report, she took a long drag off of it. Is
That's
that
correct, sir.
Based on all of this, you concluded that Ms. Austin was smoking marijuana.
Yes, sir.
Did Ms. Austin make any statements to you after being pulled over?
I believe she did, sir. Yes, sir.
Could you show me in the incident report, refer me to it?
Well, I'm looking for it, but I don't see it anywhere. I don't know if I ever put it down in my incident report, sir. I didn't put it down in my incident report.
Okay. You received training, I imagine, in the academy dealing with taking the making of incident reports
Yes, sir, I did.
and recording all pertinent and relevant facts, and even some that aren't pertinent and relevant.
Yes, sir.
So you understand the significance, including things like statements and other important information. in
Yes, sir,
an
I
incident
sure
report.
do. Yeah.
Is there anything else you left out of your incident report?
Other than her admission, no, sir, I don't recall anything else that. No. There was
All right, let's talk about what you observed for just a minute. You referred to it in your report as a hand-rolled cigarette.
Yes, sir.
Some tobacco smokers hand-roll their cigarettes, don't they?
Yes, sir, some do.
And there are several reasons why someone might roll their own cigarettes as opposed to buying the prepackaged type, right?
I suppose so.
Well, someone might roll their own cigarettes in order to save money, right?
That's a reason, yes, sir.
And some people might do so in order to avoid the additives contained in Marlboro cigarettes and things like that.
Your Honor, the defense is asking the officer to speculate on random issues here. We're here to discuss the issues of marijuana, which was found in the defendant's car, not whether other individuals take out additives or supplement additives, which the defendant obviously added her own additive in there.
I think this is relevant as it goes directly to the to reasonable suspicion, which was the basis of the stop. In this line of questioning, I'm trying to elicit if there are other circumstances under which a person might appear to be smoking marijuana, but in fact would not be, as in the case of hand-rolled cigarettes. That's why I know it's a little tedious, but that's why I'm exploring this line of
Yeah, I
questioning.
think we should just keep moving. We should move along.
Thank you.
I'm sorry, could I get a more definite ruling on that?
Just go ahead, Counselor. Continue your questioning.
Thank you. Someone might also roll their own cigarettes if they prefer expensive tobacco, correct?
I suppose so.
Excuse me, Your Honor. Can we just rule that he was to skip this line of questioning and move on
Oh,
forward?
we're already finished with that, sir. Continue with your questioning, please.
Thank you, Your Honor. Let me repeat that question again. Someone might roll their own cigarettes if they prefer an expensive brand or a better grade of tobacco, correct?
I suppose that could be a reason, yes, sir.
Okay, so it's not inconceivable if someone could smoke a hand-rolled cigarette containing something other than marijuana.
It's not inconceivable.
You stated in your report that Ms. Austin was smoking something that appeared to be about 1 inch in length. Is that correct?
She was smoking a joint that was about 1 inch in length. Yes, sir.
Objection, Your Honor. The answer is non-responsive. Could you please admonish the witness to answer the question and only the question that I ask?
Excuse me, Your Honor, the defendant was asking the officer to speculate on random issues, and here he's telling him his expert opinion as to what he thought he saw.
The question called, I'm sorry, Your Honor.
I'll let Officer Sheffield testify based on his experience.
Isn't it true that some tobacco smokers will smoke their cigarettes down to 1 inch in length?
I don't suppose that there's
Asking for speculation, Your Honor, in regard to smoking cigarettes.
I'll let him
The
continue.
question assumes that the officer has in fact witnessed persons smoking cigarettes at some point in his lifetime.
I'll let it continue.
There's no set limit on how far you can smoke a cigarette down, sir.
Good enough, good enough. And in the same vein, there are a number of reasons why someone might smoke their cigarette down to 1 inch in length.
A number of reasons, yes, sir.
A person might smoke it down that far if that was the last one they had.
That could be a reason.
They might smoke all their cigarettes down to that length because of how much they cost. They're expensive.
Could be.
What about filterless cigarettes? Some tobacco smokers prefer filterless cigarettes, don't they?
Some folks do.
And filterless cigarettes are, by design, shorter than your regular cigarette.
Yes, sir.
So some smokers might smoke a filterless cigarette down to 1 inch in length or even further because of the short length.
Suppose they can smoke it till there isn't any ashes left, sir.
So based on what we've just covered, it's entirely possible for someone to be smoking a cigarette 1 inch in length or less without it being a marijuana cigarette.
It's possible.
You stated in your report that you observed Ms. Austin holding what you believe to be a marijuana cigarette between her thumb and index finger. Is that correct?
That is correct, sir.
And you believed it to be a marijuana cigarette, among other things, because of the way it was held.
Among other things, yes, sir.
Do you agree that there might be other reasons why a tobacco smoker would hold a cigarette between their thumb and index finger?
I don't know of any.
Well, what about shifting gears? Would it be easier to shift gears for smoking a cigarette, particularly a shorter one, holding it like this as opposed to like this and trying to shift?
I suppose if you were driving a standard, it might be.
Would it not also be easier to flick ashes in the ashtray when holding a cigarette between your thumb and forefinger as opposed to between the index finger and the middle finger?
Excuse me, Your Honor. The defense is going around these entirely crazy questioning. In regard, we don't even know if the officer even smokes cigarettes or have personal knowledge as to the issues of this flickering light. If the defense is trying to insinuate that his defendant is a reckless driver, well, that's a wholly different issue. However, he's asking the officer, who we don't even know even smokes.
The reasonable suspicion in this case is based in part on the officer's experience and knowledge of such matters. I don't think it's a stretch to inquire as to whether the officer has a reasonable basis for this, to be familiar, at least in general, with cigarettes and cigarette smokers.
I'll let you continue, but I think you need to go ahead and get to the point.
Let's talk about the long drag your report refers to. Some tobacco smokers take long drags off their cigarettes, don't they?
Well, not the kind of drag she was taking, no, sir.
You've never seen someone take a long drag off a cigarette like you observed Ms. Austin?
I guess it depends on your definition of the word long, sir.
Or how do you define long?
The way she was smoking that joint.
isn't it true that the length of one's drag could depend on a high tolerance of nicotine, for nicotine?
That's possible, sir.
Isn't it possible that someone, when they're cold, might take a longer drag off of a cigarette than maybe they would normally?
Sure, yeah, I've seen that before.
And it was cold the morning of January the 6th, is that correct?
On the morning, yeah, it sure was.
What about the afternoon at 1:43?
It warmed up. I don't know what the temperature was at 1:43.
Pass witness.
Questions?
Yes, Your Honor.
Proceed.
Good afternoon, officer.
Good afternoon.
Could you please state your badge number for the record, please?
4398.
And your rank?
I'm corporal.
And how many years have you served on the force?
6 years, sir.
And, Your Honor, my approach.
Yes, sir.
I realize it's nerve-wracking up here on the stand. And sometimes numbers can get a little fuzzy, but just to clarify your record on how many years you actually served on the force, range of 19. A little over. It's okay. We'll move along. And for the record again, how many years have you served on the force?
I've served on the force for 6 years.
And before you served, did you take any training?
Yes, sir.
What kind?
I was in cadet school.
And in cadet school, what specific training did they give you in regards to marijuana?
We spent probably about a week just on marijuana itself.
Can you, if you see it, can you identify it?
Yes, sir.
What does it look like in its natural state?
It's green leafy substance, sometimes varying shades of green, from bright green for what they call kind bud, real expensive, potent marijuana, all the way to kind of a dirty leafy brown for what they call bunk, just some old commercial grade marijuana.
And when it's in a usable form, such as what they call on the street a joint,
Yes, sir.
what does it look like?
Well, joint is usually off-white in color, a little bit tapered on one end, about that long, somewhere around there.
About how long?
I guess it depends, about that long.
About that long.
Yes, sir. Depends on who rolled it, as to how it looked.
So as a trained officer who took classes, could you be able to see and know what a self-rolled marijuana joint looks like?
Well, I can tell you that I've never seen a manufactured joint.
Yeah. You know what a joint looks like.
Yes, sir.
And how does a pot smoker hold a joint?
Usually like this.
Will the record reflect that the officer showed the thumb and index finger?
Your record will so reflect.
And in regards to your training, do you know what marijuana smells like
Yes, sir.
when it's being smoked?
Yes, sir.
And do you know what the ashes, what they would smell like as well? Or they would look like?
I know what the ashes would look like. I don't think the ashes have a smell.
Okay.
It smells kind of burned off of them.
And as an officer of so many years, have you made previous stops for possession of marijuana?
I've made many stops where possession of marijuana was involved.
How many would you say in a day?
In a day?
Yeah.
I think I've had up to 3 in a day.
Okay, and in a month, perhaps?
I don't know. I don't sit around and count,
Yeah, just approximate. For instance, this past month of June.
I think so far I've made 2 arrests for possession of marijuana this month.
Okay, so let's just say two for here. Would it be so far stretched to say that you would perhaps get 3 in a month
I mean,
on an average?
Last month I was involved in a search warrant raid where we got 7 people in one house at once.
Okay, so you're very well experienced in regards to marijuana.
Yes, sir.
So you were on patrol. Where were you on January 6th, 2004 at 1:43 p.m.?
I was cruising down Guadalupe Street southbound.
And how was the lighting? Was it dark or anything?
Well, I don't want to say it was dark, but it wasn't a bright sunny day like today either. It was a little bit overcast and drizzly.
Your Honor, may I use demonstrative evidence? Demonstrative?
Yes.
Can you see over here, officer?
Yes, sir, I can.
Great. Just quick north, south, west, east.
Okay.
I want to give everybody an actual physical view of what everything's seeing. You can get words can get cluttered and misunderstanding, so I just want everyone to be able to see what's going on, what we're talking about. Okay, here's what, would you say this is Guadalupe? What is this right here?
It appears to be Guadalupe Street southbound.
You know, maybe the officer can approach, please.
Absolutely.
Sure.
And where was your car at the time when you first saw?
When I first saw her, somewhere around the middle of the block.
And where was the defendant?
Well, the defendant was approaching me. When I first saw the hood of her car, she was a little bit behind me.
Okay, and when you first saw the defendant, what did you notice?
Well, I noticed it was a black Chevy Camaro.
And in the previous testimony, you said they were tinted.
Yes.
So were they dark or light tinted?
Well, it had the mother's window tint sticker on it. It was in compliance with the transportation code.
So could you see inside?
Yes, sir.
Okay. And did you ever come even?
Yes, sir.
And when you looked in, did you see anything unusual?
Yes, sir.
What did you see?
She was smoking a joint.
Objection. I'm sorry. These are just leading questions.
I asked, what did you see?
Not just that one. I'm just.
I'll let him continue.
What did you see?
I saw Miss Austin holding and smoking a joint.
And what did that joint look like?
It was about that long, off-white, hand rolled.
So you saw a white, hand rolled,
Well, it was off-white. It was
okay, off-white,
I almost say it was as white as that board you drawn.
okay, off-white, hand rolled
Yes, sir.
joint.
Yes, sir.
And what is inside a joint again?
Marijuana.
Marijuana. And that is this an illegal substance?
Sure is.
And that is what you saw at the time when they were passing.
Yes, sir.
And what happened when y'all were continuing driving?
Well, I guess it was right around here. I think it was right in front of the Clay Pit restaurant where our cars were even. Because there was a car in front of me at the red light, and I was having to apply my brakes harder than Miss Austin. And that's when she entered into my peripheral vision, and I saw her taking a hit off the joint.
How good was your sight?
I mean, I got 20/20 vision.
And how was your line of sight?
It was directly across to my right.
And what is over here?
What do you mean?
What is this right here
Well,
called?
that's the intersection of
Intersection.
15th and Guadalupe.
And what was here?
There was a
You were
car.
on the same?
Yes, sir, there was a car. It was, actually, the car was in front of me, traveling the same direction I was traveling. It's just that car made it to the red light before I did.
And you said that you were applying your brakes because you were heading to a light.
Yes,
Where did all the cars end up positioning at the light?
Well, let's see, at the light, my car was the second one at the light.
I'm sorry. Could you do something with that board there? I can't seem to. Just so I can see, please. Thanks.
Miss Austin's car was the first person at the light. There was a car in front of me that was the first person. I was the second person at the light in the left-hand lane.
Now, I don't know about you, but I'm not a great artist myself. But
Yes.
I don't consider Michelangelo, and I'm sure you don't as well. Where in the vehicle would you say you were sitting?
I was sitting in the driver's seat.
And where was the defendant?
She was in her driver's seat.
Could you mark a line?
Yes, sir.
Could you see her when you were sitting, when you were standing there? When you were
I
waiting?
could see her shoulder, yes, sir.
Did you see any movements?
No, sir, she was just, I mean, I didn't see her taking out the drag at the red line.
And was there anyone else in the vehicle with her?
Yes, sir, there was a passenger, I believe his name is Larry Joe Watson.
And what does the defendant look like?
Well,
Can you see any physical features?
she's white, Caucasian female, about 5'4", 110, 15 pounds, light brown hair, blue eyes, light complected.
And do you see that individual here today who you stopped?
Yes, sir.
Can you please point her out to the court?
Yes, sir. She's sitting right next to the defense attorney right there.
And reflect on the record that the officer was able to identify the defendant. Your Honor.
Yes, sir.
Thank you. You can continue. Thank you so much, officer. Officer, just a few more quick questions, if you may allow me. So you saw an off-white hand-rolled joint marijuana in her hand,
Yes, sir.
and you testified that you saw her take a drag.
Yes, sir.
How long was the drag, would you say?
It was about this long.
For the record, they need to know a couple of seconds, if you could approximate.
Sure. About 3.5 seconds.
3.5 seconds. May the record reflect the actions of the officer.
The record should so reflect.
So about 3.5 seconds. And you said that they were that the defendant was holding it how?
Just like that. Like that right there.
Index and thumb?
Yes, sir.
And in your expert opinion as an officer, is that a common way for pot smokers to hold a joint?
Yes, sir, it is.
Objection. Characterization of client.
I'm not characterizing the defendant at all. I'm just asking in his expert opinion as to how pot smokers hold their joint.
I'll let it continue.
Thank you. And so you saw all these various items. Did you pull the defendant over?
Yes, sir.
And when you pulled the defendant over, was there anything unusual?
I wouldn't say it was anything unusual. I mean, she responded to my lights all right.
I'm sorry?
She responded to my overheads and pulled over.
Okay. And then when you approached to investigate, as you commonly do,
Yes, sir.
Was there anything unusual when you approached the defendant?
Well, that's when I noticed she had a passenger in the car with her.
Okay. She had a passenger?
Yes, sir.
And anything else?
Black interior, automatic transmission.
What about in the environment?
What do you mean?
Such as odors or anything of the nature?
I smell the odor of marijuana.
So you smelled marijuana?
Well, after she rolled down her window, yes, sir.
So there is, and as a testifying expert officer, are you familiar with the smell?
Yes, sir, I am.
And part of your investigation, when you smelt the marijuana and you saw the off-white hand-rolled joint in the hand of the defendant, did that cause any reasonable suspicion?
Well, I didn't smell the marijuana and see it in her hand at the same time. When I smelled the marijuana, the joint was in the ashtray.
Okay. Let me ask you this. Why did you pull over the defendant?
Because I saw her smoking a joint.
And when you further investigated, you just recently testified that you smelled marijuana.
Yes, sir.
And when you further investigated, and did you ask the defendant any questions?
After I got her out of the car, yes, sir.
Mm-hmm. And when you got her out of the car, did you take the other individual out of the car?
Yes, sir.
And what did you do then?
Well, I took him back to the back of the car, and I told him, I said, I need to know whose weed it is. At first, neither one of them wanted to say anything. And then I told him, I said, I need to know whose weed it is. I'm fixing to go search the car. They both just stood there real mute-like. So I went and found the weed, and then I came back with it in my hand, and that's when she said, it's mine, officer. You don't have to take him in.
And where did you find the weed?
I found it under her seat.
Under which seat exactly?
The driver's seat, sir.
And who was driving?
Angela Austin was.
The defendant?
Yes, sir.
Okay. And what was in the bag?
Green leafy substance, marijuana.
Green leafy substance, marijuana. And that was in the physical possession. And who admitted to possession of the marijuana?
Well, I mean, after I asked her the third time, whose marijuana is this, she said, it's mine, officer.
So the defendant openly declared to the officer that it was hers.
Yes, sir.
And after you made the arrest, what did you do with the evidence?
I brought it in to Sergeant Polivka.
And what is the customary practice of investigating officers to do with such evidence?
Well, it's to turn it in to the evidence locker, and that's who was running the evidence locker. We both weighed it. It was 19 grams of weed. He even field tested it. It was marijuana.
Pass the witness. Thank you, officer.
Just a couple more questions.
Okay.
Ma'am? Officer Sheffield, let me just ask you a couple of questions about this diagram here. I'm curious about a couple of things. You said that, that the hit, the drag
Yes.
that you observed lasted approximately 3.5 seconds.
Somewhere around there, sir.
You also said, when you were up here at the board, that you actually only got a split-second glimpse of her as you threw on your brakes to stop
Yes, sir.
behind the car.
Yes, sir.
And so, given the distance and the speed we're talking about, are you sure that those seem to contradict one another?
Well, I don't know about contradict. I didn't have a stopwatch that day. I'm just giving you an estimate of how much time it took him to take that
So it's
drag.
possible that you actually just caught a split-second glimpse.
Well, I saw her take a hit off of it, sir. I don't know how many seconds it was.
And you didn't once stopped at the light at 15th and Guadalupe. You actually never saw Ms. Austin take a hit off anything once stopped at the light.
Not one stop at the light, that's correct.
So the only time you saw anything was as she was coming up on you just prior to pulling on your brakes.
Yes, sir.
Let me ask you something with regard to this. He said that was an off-white hand roll. Is that correct? Did I read
Yes.
that correctly?
Yes, sir.
Yeah, and as you'd already stated, it is not uncommon for cigarettes to be hand rolled.
I didn't say it wasn't uncommon, sir.
Well, you have seen a hand rolled cigarette.
I have, yes, sir.
Okay. Okay. Hand rolled joint, off-white hand rolled joint marijuana. Do you have X-ray vision, officer?
No, sir.
So you could, in a split second, as she just came up on you, you saw in that split second, you could tell that she was not only smoking something that was hand rolled, but that it contained marijuana.
I couldn't see the marijuana in it, sir, but I could tell what it was.
No more questions. Pass the witness.
No, just a couple questions. In my haste, I forgot to ask you one quick question in regards to the investigation. Since someone smokes, there's obvious ash. What was inside the ashtray?
Ashes?
Anything in particular about them?
What do you mean?
Did you smell them?
I didn't smell the ashes, no,
No,
sir.
but there were ashes inside.
Yes, sir.
Were they warm?
I didn't touch them, sir. I mean, there weren't any cigarettes in that ashtray, other than that marijuana cigarette.
Objection.
Judge, your basis for objection.
I'm sorry, I'm sorry. His answer was non-responsive again.
I'll let it continue.
Yes.
Officer, in your training at the academy and your years on the force, I'm assuming you know the rationales and how to stop the legalities of stopping an individual, so you yourself don't break the law.
I would hope so, sir.
Could you please tell the court what those are? What the legality aspect of being able to pull someone over?
Objection. The witness isn't an attorney.
No, but he is a trained officer, and and as an officer must have reasonable suspicion to be able to pull a client over, a defendant over. And that I'm just asking the officer to do, is just to simply state what is reasonable suspicion.
Officer is presumed to know the law and enforcement. If you want to ask the question, I'll let him answer it.
That is what I asked.
Well, I mean, if you see that somebody's committing a crime, you're supposed to pull them over.
And did you have reasonable suspicion?
I would hope so, sir.
Yet. Okay, rather, would you say did you have probable cause to pull the defendant over?
I guess that depends upon the definition of probable cause. I felt like I did. I saw her smoking a joint in my presence.
What is your definition of probable cause?
Well, it's when more likely than not it's a crime happening.
Objection. How is the witness's definition of probable cause relevant to the law?
Well, the officer is presumed to know the law that he's enforcing, and if the prosecutor wants to ask him about his interpretation of the law, I'm inclined to let him answer it.
While that is correct, I believe he's being asked about his own notion of the law. I don't understand.
As an expert.
Maybe it was just me. I don't.
As an expert
I withdraw my
police officer.
objection.
Excuse me, officer, in your training, they obviously taught you about probable cause.
Yes, sir.
In other words, why do they teach you that?
Well, so that you're aware of what it is.
So you're aware of what it is?
Yes, sir.
Is that you would have, and you're aware of what it is. Were you aware of the defendant's actions?
That's why I pulled her over, yes, sir.
No further questions.
I'll allow argument. Oh, I'm sorry, Mr. Sheffield.
May I be excused?
No further questions, you may be excused.
Hold argument for just a second.
Okay, I'm gonna hold argument for one moment.
Your thoughts for argument.
Allow argument.
Your Honor, the defense contends that each and every observation made by Officer Sheffield was consistent with otherwise innocent activity. The hand-rolled cigarette, the manner in which it was being held, okay, the length. We also contend that given the amount of time that we're talking about here, namely a fraction of a second before stopping at the light, was insufficient amount of time to place a whole lot of weight in any observation made, given that there was nothing that, once at the light, that Officer Sheffield was unable to see any further. There's no evidence of any traffic violations, erratic driving, any evidence that Ms. Austin attempted to conceal what she was doing. There's no evidence of anything being passed back and forth between herself and the passenger, or a roach clip, or other paraphernalia being used. This does not meet the level of reasonable suspicion required by the law. Under Davis, we need specific articulable facts based on the experience and knowledge of the officer, notwithstanding, it's something that still has to be objectively reasonable. Okay? The officer may think one thing, he may have thought that he saw one thing, but when there are completely innocent explanations for it, the officer cannot be allowed just to pull people over essentially at random on his own whim, on nothing more than a mere hunch. The law requires that the activity be out of the ordinary, and we submit that there was nothing that the officer observed on the afternoon of January 6th that was out of the ordinary. And as such, the stop was illegal, and anything obtained as a result of such stop should be suppressed. So in short, we pray that the court grant the defense's motion to suppress in this matter. Thank you.
Thank you, Your Honor. Before us here, we have a defendant, Miss Angela Austin, who was caught on January 6th this past year with a hand-rolled joint in her hand, and upon further investigation by the officer, found over 19.5 grams of marijuana under her seat. And as the testifier just recently said, she openly admitted to the fact that it was hers. She openly admitted that it was my marijuana. I am guilty of this issue. And in this world, we grow up knowing math is 1 + 1 = 2. The defense would like you to think 1 + 1 = 1,000,000, trying to confuse all the issues. And in this issue, we have an investigating officer, Mr. Mike Sheffield, who has testified he is well trained, attended the academy, and has several years on the police force. And even further testified that he has seen many investigative issues regarding marijuana and has pulled over many individuals himself. Actually, he just pulled over 2 this past month. Officer Sheffield testified that while driving southbound on Guadalupe Street, he saw the defendant, Miss Angela Austin, with an off-white hand-rolled object, a joint filled with marijuana. He saw him take a long drag. He saw Miss Austin take a longer drag than what is usual. He saw Miss Austin hold the marijuana joint index to thumb, which, as officer testified as expert testimony, is commonly used by pot smokers. And upon his investigation, which he did say, he had a reasonable suspicion as to why he pulled the defendant over. And then upon further investigation, he smelled marijuana. And rather, if you look at the report, a strong odor of marijuana, which by any objective standard would give any person, officer or not, reasonable suspicion of a criminal activity. Further, upon his investigation, based on the suspicion, he looked under the car seat, and what did he find? A green leafy material, which he suspected was marijuana, based upon the fact that he saw a hand rolled, a long drag, index to thumb, a marijuana smell, and then he found a green leafy substance. And he saw ashes in an ashtray, but yet no cigarette. Which, as the defense was asking the officer to keep testifying about cigarette smoking, they never asked the question about, upon smoking a cigarette, there are always cigarette butts in an ashtray. But yet in the investigation, there are no cigarette butts. However, upon the defendant, in the report, you see a smoldering ash. Not cigarette butts, but smoldering ashes. Nowhere is there anything in regards to cigarettes. Again, they're trying to make you believe 1 + 1 = a million. We're just throwing simple facts that clearly state that 1 + 1 always equals 2.
Can I ask you a question, Counselor? I'm a little bit unclear on what it seems to me that counsel for the defense is arguing that there was no reasonable suspicion to stop.
Yes.
Can you explain to me what your argument is on the reasonable suspicion?
Yeah. In regards to the reasonable suspicion aspect, Your Honor, under the law, an officer whether a reasonable person would have believed that a reasonable suspicion existed. The officer in question, Officer Sheffield, drove by and was directly next to the defendant, and saw the defendant smoking what appeared to be a marijuana joint in an unusual fashion, rather. And as the defense clearly stated himself, that there's different ways, but he was testifying as to his expert opinion as an investigating officer, and what caused his reasonable suspicion was what he saw: the white 1-inch object, along with a long drag furthered by the index to thumb, which to an investigating officer all leads to marijuana and smoking. Again, 1 + 1 = 2.
So I guess my question is twofold. Does the fact that he smelled marijuana, does that have anything to do with the reasonable suspicion?
That has great meanings into what the reasonable suspicion, in that he smelt this strong odor of marijuana coming from the vehicle, which gave him reasonable suspicion to have the opportunity to investigate the vehicle.
And what about the fact that he ultimately found marijuana in the vehicle? Does that have anything to do with the reasonable suspicion?
He had a reasonable suspicion based on everything we've listed up there, and then he asked if he could investigate, and they allowed him permission to review the car. And once inside, he found the marijuana.
Okay. Any further argument?
No, Your Honor. No. Well, actually, just one quick. And in furtherance of the site that the defense was bringing up, in the tent, there was light tint. It was a clear, bright day. It wasn't dark. It wasn't shady or anything of that nature. He had a clear sight of the defendant and the defendant's actions.
I have just a few words, John. Oh. Let's see, innocent activity, innocent activity, innocent activity. The Fourth Amendment, with all due respect, the state seems to be trying to bootstrap the stop on what was subsequently found. The Fourth Amendment doesn't care what was found, it only cares the manner in which it was discovered. It's irrelevant that pot was subsequently found in the car. The question is, was there reasonable suspicion as required by law for the initial stop? The smoke coming out of the window matters not. That doesn't have anything to do with whether the stop in itself, the detention, was justified. The officer's reasonable suspicion. It doesn't, the officer's belief that reasonable suspicion existed is also irrelevant. It's an objective standard. The Fourth Amendment would mean nothing if officers were, if stops and searches were upheld because they thought that they were acting within the bounds of the law. Anyway, in conclusion, there's not one observation that was made that couldn't be explained away by innocent activity. The stop was not justified by reasonable suspicion, and as a result, anything seized thereafterwards should be suppressed. Thank you.
I'll take this matter under advisement. Thank you.